Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about specific personal jurisdiction in the context of a case cited in Texas. It's one that'll sure to get you charged up. We'll have more down here at the beach in just a minute. So this is the tale of a guy by the name of Tommy Morgan who went into a vape shop and bought himself a battery for his e-cigarette device, his vaping device. He bought an 18650 battery, a lithium-ion battery, stuck it in his pocket, and for whatever reason, it exploded and injured him. And so he went to see an attorney, and the attorney said we should sue, and indeed that's what they did. And rather than getting into the whys and wherefores of why their battery suddenly blew up in this poor guy's pocket, these companies did the thing that companies always do, frankly. They challenged jurisdiction. What they basically said was, hey, Texas, you got no business taking us into court. Well, the Texas District Court disagreed with that, and the Texas Court of Appeals disagreed with that, and they petitioned the state Supreme Court, and this is the state Supreme Court's opinion on whether they could be brought into court in Texas. LG Chem America Inc. and LG Chem Limited versus Tommy Morgan. This is a products liability case in which two non-resident defendants contest personal jurisdiction. The plaintiff bought a lithium-ion battery at a store in Texas and was injured when he used it to charge his e-cigarette. The defendants do not dispute that they sold and distributed the same batteries to Texas manufacturers, yet they urge personal jurisdiction is lacking because they did not send the batteries to Texas for resale to individual consumers to use with e-cigarettes. Rather, they only expected that the manufacturers would incorporate the batteries into branded consumer products such as cordless power tools and laptop computers. They argue the plaintiff's claims arise out of the use of the battery in a way they never intended by an individual consumer they never targeted, and thus are insufficiently related to the defendant's Texas contacts to justify hailing them into Texas courts. We hold, consistent with our precedents, that the minimum contacts analysis requires evaluation of the defendant's contacts with the forum, Texas, as a whole. Whereas here, a defendant purposely avails itself of the privilege of doing business in Texas by selling and distributing into Texas the very product that injures a plaintiff, personal jurisdiction is not lacking merely because the plaintiff is outside a segment of the market the defendant targeted. Put differently, the relatedness prong of the minimum contacts analysis does not require that the plaintiff's claims arise out of a set of facts mirroring the defendant's expectations about the course its product would follow after it entered Texas. The trial court and the Court of Appeals correctly concluded the exercise of personal jurisdiction over the defendants is, on this record, consistent with due process. Now, it's worth noting that in addition to this case, which reached all the way into the Texas Supreme Court, the company had been sued by a number of other people for, I guess, essentially the same exploding battery. And courts in different jurisdictions, and indeed even in Texas, had reached different results, which they set out in a footnote. But what's interesting about that is, and the way the court distinguishes that, is it later on says, look, we're not saying those courts got it wrong. We're talking about the evidentiary record that reached us. And the thing that I think is probably the most entertaining here is that the defense attorneys in this case never challenged the affidavits, their veracity, or how it was that they were able to show all of this stuff that came in through the ports in Texas. There might have been a number of exceptions that they could have used to keep that information out, but instead it came into the record and it formed the basis for personal jurisdiction in this case. Tommy Morgan, a Texas resident, was injured when lithium-ion battery exploded in his pocket. Morgan purchased the battery, referred to by its model number, 18650, from VaporSense, a store in Texas, to charge an e-cigarette he bought at the same store. The model battery that injured him was manufactured by LG Chemical, a company headquartered in South Korea, and marketed by LG Chem America, who is the distributor here in the United States. It was sold by this company, VaporSense, and in the original petition for damages, this is what Morgan said about jurisdiction. It said LG Chemical is in the business of selling, exporting, importing, distributing, and otherwise introducing lithium-ion batteries into the stream of commerce and was conducting business in the state of Texas in a continuous and systematic manner by marketing or selling its products in the state of Texas. And then it made the same general arguments about LG Chem America, that it works in conjunction with LG Chem for selling, importing, distributing, that sort of thing. The lithium-ion battery that injured Morgan was manufactured, marketed, sold, distributed, or otherwise placed into the stream of commerce by LG Chem America and or LG Chem. And at all relevant times, defendants were engaged in the business of selling or otherwise intentionally placing batteries into the stream of commerce and directing such products to Texas, including the battery that injured Morgan. So as what usually happens when you get one of these companies that's extraterritorial, they'll file a motion to dismiss. In Texas, you do that through a special appearance, because if you appear and answer, you have basically, you've basically given up the jurisdictional argument. So they make a special appearance and they provide an employee's affidavit. Neither affidavit denied that LG Chem or LG Chem America directed the sale and distribution of its products, including lithium-ion batteries, to Texas. Instead, the affidavits denied that the defendants sold or distributed their batteries for use by individual consumers, and that they never authorized any manufacturer, wholesaler, distributor, retailer, or reseller to distribute, advertise, or sell their batteries directly to consumers as standalone batteries. And then the compliance manager, Hyun-Soo Kim, averred that LG Chem America has never sold or distributed any power cells meant for e-cigarettes or vaping devices. Or has it sold any brand power cells in Texas or anywhere else for use by individual consumers as power cells in e-cigarettes? And when I think about that argument, I think about it as kind of a silly argument, in that just because you don't intend for it to be sold directly to consumers doesn't mean that it's not going to be. It's like Ford Motor Company coming in and saying, well, the Uber driver bought this vehicle from Ford and he didn't tell us that he was going to use it for an Uber. And then when the lady in the back seat of the Uber got hurt because our car was defective, well, we had no way of knowing that, and so we didn't target her. We just were selling cars, and we didn't have any idea that they were going to be used as an Uber. It's a really stupid argument because you sold the vehicle, you put it into the stream of commerce, and how it eventually reaches the consumer that it reaches is really of less importance than the fact that you intentionally sent it there to be sold. So I think just sort of at the outset, that's a dumb argument for them to have made. So Morgan had an opportunity to respond to that special appearance. And Morgan says, look, you're both subject to special jurisdiction because you shipped those batteries into Texas. So in addition to that, he submits a declaration from his attorney that shows over 2,000 pages of spreadsheets reflecting U.S. Customs data from November of 2006 through May of 2019, showing LG Chem's shipments of thousands of products to Texas companies or through Texas ports. Some, but not all, of these entries seemingly show that LG Chem shipped lithium-ion batteries and specifically Model 18650 batteries, to Texas. They note that it generates about 1/15 of its total revenue in Texas. Neither defendant objected to the spreadsheets or other evidence attached to Morgan's responses. Following a hearing at which no additional evidence was offered, the trial court denied both special appearances. Normally, when something like this goes against you, you can either take a writ in some states or file what's called an interlocutory appeal, and that's what LG Chem did. They took it up to the Texas Civil Courts of Appeal, and the Court of Appeals affirmed, concluding that each of the products that injured Morgan injured him in Texas, and it arises from or relates to their conduct in designing and marketing batteries for the Texas market. And with respect to LG Chem America, the court likewise concluded that Morgan's claims arise out of LG Chem batteries, and LG Chem marketed, sold, and distributed those to people in Texas. So the LG Chem folks filed petitions for review in the Texas Supreme Court, which the Supreme Court granted. As I mentioned, there were a number of various views about whether or not there would be jurisdiction in the different district courts and courts of appeal in Texas. And I suspect that had a lot more to do with them taking the appeal and deciding this jurisdictional case than did the actual merits of the appeal. I think they wanted to kind of put a ribbon on this personal jurisdiction analysis. The applicable law. A court has to have personal jurisdiction in order to issue a judgment, and Texas courts can issue personal jurisdiction over a defendant if it is authorized by Texas long-arm statute and consistent with federal due process guarantees. The long-arm statute permits courts to exercise jurisdiction over a defendant who does business in this state, a non-resident defendant who commits a tort in whole or in part in this state. A non-resident defendant may challenge the Texas court's personal jurisdiction by filing a special appearance. The plaintiff bears the initial burden to plead sufficient allegations to bring the non-resident defendant within the ambit of the long-arm statute. The defendant then bears the burden to negate all bases of personal jurisdiction alleged by the plaintiff, and they can do that either legally or factually. Now, a state court's exercise of personal jurisdiction over a non-resident defendant is constrained by the constitutional guarantees of due process under the 14th Amendment. And so there have to be both minimum contacts with the forum state, and those contacts have to make it so that maintenance of the suit is reasonable and doesn't offend traditional notions of fair play and substantial justice. In giving content to that formulation, the court has long focused on the nature and extent of the defendant's relationship to the forum state. To the extent that a corporation exercises the privilege of conducting activities within a state, it enjoys the benefits and protection of the laws of the state. And it's in this next segment that I think the Texas Supreme Court really put a bow on this issue of personal jurisdiction and minimum contacts. I like the way it contrasts benefits with burdens. And although it's not speaking necessarily exactly in those terms, what it basically says is, if you come here to do business, you need to expect to be sued here. So let's pick up with the opinion. Those benefits and protections include the enforcement of contracts, but the state's assistance creates reciprocal obligations, including an obligation that products the defendant sells or distributes are safe for its citizens to use. Now, there are two specific kinds of personal jurisdiction: the general, sometimes called all-purpose jurisdiction, and specific. General jurisdiction is where the company is physically present in the jurisdiction. And specific relates to events that arise that cause it to be within the state or in the state for purposes of jurisdiction. And the only question here is there specific personal jurisdiction? As noted, to establish specific personal jurisdiction over a non-resident defendant, a plaintiff must demonstrate that the defendant has minimum contacts with the forum state such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. This specific jurisdiction analysis revolves two co-equal components: purposeful availment and relatedness. First, a defendant must have purposefully availed itself of the privilege of conducting activities in the forum state. In cases involving products liability, this court has adopted the stream of commerce plus standard to establish whether this purposeful availment exists. Under that standard, the defendant's act of placing a product into the stream of commerce does not establish purposeful availment unless there is additional conduct evincing an intent or purpose to serve the market in the forum state. Simply knowing that the defendant's product is going to reach the forum state is not sufficient. Second, the plaintiff's claims must arise out of or relate to the defendant's contacts with the forum. This so-called relatedness inquiry defines the appropriate nexus between the non-resident defendant, the litigation, and the forum. Under our precedents, the plaintiff must demonstrate a substantial connection between the defendant's contacts and the operative facts of litigation. What courts do a terrible job of explaining here is that what you want to be able to show is that something the defendant did, either coming into the state or selling its product in the state, caused injury in part to the person who is suing. You want there to be a connection between the defendant's actions within the state or his sending products into the state and what actually happened to the plaintiff. If a defendant makes two products, one of them is a drill and the other one is a chainsaw, and they sell the drill into the state, but they don't sell the chainsaw into the state, and the plaintiff gets hurt with the chainsaw, you're going to have a hard time showing that there's a connection there just because they sold the drill, because the drill does not cause the injury in that situation. So that's all they're trying to do, is show that by virtue of finding all of these factors, that there is fairness in applying jurisdiction. The U.S. Supreme Court recently examined this in the Ford case, and in that situation, they found that personal jurisdiction wasn't there because there was nothing that really connected the products that were being sued over to the state where the lawsuit was brought. In other words, the plaintiffs were hurt in other states. They sued in California, and they weren't suing for torts that occurred in California. They were just suing because other people were suing in California. So the court analyzes it this way. Neither L.G. Kim defendant disputes that it purposely availed itself of the privilege of conducting activities in Texas through the sale, shipment, or distribution of Model 18650 batteries. Instead, they say, look, because Morgan's claims don't arise out of or are insufficiently related to those contacts, they fail. In particular, they emphasize that the evidence shows they never sought to serve a consumer market for 18650 batteries. The L.G. Kim defendants describe the batteries they manufacture and sell and distribute as industrial components that are suited more for power tools or laptop computers. Because they target industrial manufacturers and not individual consumers like Morgan, the argument goes, Morgan's claims aren't related. This court has never endorsed the L.G. Kim defendants' proposed granulation of the forum into those you intend to serve and those you don't intend to serve, or into distinct market segments. Rather than focusing on the nature and magnitude of their contacts with the sovereign forum and the close relationship of those contacts to this litigation, the L.G. Kim defendants urge us to shift focus to whether the plaintiff is within a particular Texas market segment, the industrial component market they intended to serve. Accordingly, here, the L.G. Kim defendants' supposed intent to serve only industrial consumers in Texas is of lesser importance than the larger and dispositive question, whether it would violate due process for Texas to exercise personal jurisdiction over the L.G. Kim defendants when Morgan was injured by the very product, the Model 18650 lithium-ion battery, they sold and shipped to Texas by the thousands. This conclusion is inescapable given our precedents, which uniformly treat the whole forum, the entire state of Texas, as a relevant market in the minimum contacts analysis. Here, the L.G. Kim defendants intended to serve Texas market for the Model 18650 batteries, the same model market that Morgan alleges exploded in his pocket and injured him. But there is no requirement for jurisdictional purposes that the market segment the LG Chem defendants serve be precisely the same one from which Morgan purchased the battery. LG Chem defendants argue the court's analysis must focus on the absence of any intent. Otherwise, they say they will be subject to jurisdiction without the clear notice that due process requires. We disagree. As Ford teaches, an automaker regularly marketing a vehicle in a state has clear notice that it will be subject to jurisdiction in the state's courts when the product malfunctions there. Texas' exercise of personal jurisdiction over the LG Chem defendants for a claim based on a defective Model 18650 battery does not deprive them of due process simply because they may not have anticipated the claim would be brought by someone outside their intended chain of distribution. The LG Chem defendants also assert that clear notice is lacking because they cannot structure their Texas-directed conduct to avoid exposure to consumer lawsuits. But avoiding the Texas market altogether is not the defendant's only option. Defendants can also act to alleviate the risk of burdensome litigation by procuring insurance or passing the costs on to consumers. LG Chem and LG Chem America do not dispute that they purposely availed themselves of the privilege of doing business in Texas by selling and distributing their Model 18650 batteries in Texas. Morgan alleges he was injured by a defective Model 18650 battery manufactured by LG Chem. Despite the LG Chem defendants' claim that they did not intend to serve a market for individual e-cigarette battery consumers such as Morgan, we hold that Morgan's claims are sufficiently related to the LG Chem defendants' undisputed contacts with Texas to satisfy due process. Because the LG Chem defendants are subject to specific personal jurisdiction in Texas in this case, we affirm the Court of Appeals judgment. Well, I have to give LG high marks for what I would call a novel argument. The idea of looking at intent, and intent specifically to serve a market segment, is not something that had ever been part of the past jurisprudence into specific jurisdiction. Saying, it's kind of like the bully in the schoolyard saying, I never meant to hurt him. He just kept smashing his face into my fist. You know, the idea that you sell a product and it harms somebody, irrespective of whether you sold it to power a laptop or power an e-cigarette, it still hurts somebody, and you still ought to make it right. So that's what I have for you today. Hopefully this has been interesting, educational. It's a little bit more on specific personal jurisdiction, which is something that comes up quite frequently in product liability and tort cases generally. If you have any questions, leave them in the comments down below. Like, share, subscribe, you know all that stuff we ask you to do. And today I want to take a moment to comment about my grandson. I have a grandson who is known at school for being kind to other people and always saying nice things to them. Nobody told him to do that. Nobody trained him to do that. He just intrinsically knew that that was a good thing to do. And I like to think that maybe he trained me to think in terms of kindness. So again, if you have the opportunity today, go out of your way. Do something nice for someone, even if it's just letting them into the stream of traffic. Thanks again for watching. Have a marvelous day. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.